welcoming Dr. Philip Dunphy.
Thank you. Hi, I'm Phil Dunphy. I'm a mediator. I've been doing mediation since 1993. That might not sound like a long time for some of you, but it is for me. I mostly work in family mediation through receiving referrals through the domestic relations court in the county that I work in. But it's becoming a larger and larger opportunity to work with families, with people who, for example, seniors who have reached some cognitive or physical disability where decisions need to be made for them, and those who are closest to them are concerned in regards to how to care for them. And so family would come together, and there might be disagreements in regards to how that happens. So mediators, like myself, would come and work with a family to help them make decisions that are good for all the people involved, not just one of the people involved. So when I talk about elder care mediation, elder care, you could substitute the word probate mediation or elder care or senior mediation, but specifically where it is that I'm gearing the presentation today is towards how mediation works and how it can be applied to caring for those who have reached the point in their life where there's some physical or mental problem where they can no longer make decisions or care for themselves. Just for a working definition, okay? Okay, so wrong device.
Can you turn off the center light?
I think mediation is a good idea. Not just myself, Abraham Lincoln thought it was a good idea, even though he doesn't necessarily say that mediation in here. He does say to discourage litigation and pursue a compromise whenever it is that we can. When I talk about litigation, litigation is the traditional avenue that people seek in solving problems in the United States. And mediation, by and large, is an unheard of alternative dispute resolution process. So Abraham Lincoln thinks it's a good idea. Former Chief Justice Warren Burger the Supreme Court says it's a good idea, that the justice system has gotten to the place where it's getting crazy out there, that litigation is getting to be insane. He says that the system's too costly, too painful, too destructive, and too inefficient for really civilized people. And he speaks up, is a great advocate for mediation, and says that there needs to be a different way that we solve disputes other than going to court and suing each other. And also, to pull out the Bible card, the Bible as well in Matthew chapter 5 says, settle disputes quickly before your adversary takes you to court. It doesn't say mediation, but it does say it's best to stay out of court and to work on solving your disputes together as opposed to using the judicial system. So what I'm going to do is I'm going to start from Conflict 101, explain why conflict happens, explain what mediation is, explain what a mediator does, and then talk about how it can be used in elder care mediation. That's my point, that's my purpose for being here today. Conflict happens because there's limited resources. It could be finances when it comes to elder care, or when it comes to a divorce and there are children. There's only a limited number of children, there's only a limited number of time that children can spend with parents, and there's limited numbers of resources available. And when there are limited resources, people compete for those resources, and it causes conflict. Sometimes people see the same circumstance and they draw different conclusions. And so therefore there are misunderstandings in regards to how things take place. Sometimes there are just differences. I believe one way, you believe another way. attitudes give way to belief, or attitudes give way to behavior, and so I act a particular way that you might find disagreeable or offensive, and so therefore we're in conflict. Sometimes my expectations are that you should be this way, or that you should do this thing, and then when you don't meet my expectations, then I get upset, and then we're in conflict. And sometimes it's just power and authority. People use power and authority maybe inappropriately. Maybe those people who don't have power and authority feel offended because they feel helpless, and then conflict ensues because there's a misbalance of power and authority. So, mediation is something that we can do in order to resolve the conflict. By definition, mediation is a process in which we meet privately, out of the public eye, confidentially, and seek to work out the solution with a neutral person. And the neutral person there, working with the parties in conflict, would be a mediator like myself. And mediators have a bag of skills or a skill set that we use. It's called soft skills. It's not skills that a lawyer would have that would be considered hard skills. They know the law and how to apply the law. Mediators have what are called soft skills, where they understand people, they understand conversation and communication, they know how to reframe statements and arguments, they know how to soften statements in order to get the other person to hear what their opponent is saying in mediation. And so we act as a neutral person. Neutral means I don't take one side's point of view more than I take the other side's point of view. It's a place where I don't believe one party more than I believe the other party. I just simply am there, not concerned so much about what the outcome is or who's right or wrong, but just as long as they receive an outcome that they both can live with when they leave the mediation room. I don't act as a judge. I don't act as an arbiter. I don't decide. I can't say you're right or you're wrong. I can't say you can't do that. I can't say the court would never agree with that. All I can say is, will that work for you? I might challenge the decision in terms of, let's just imagine how that plays out. Can you imagine what the consequences of that decision would be? Let's think it through. And maybe if we come to the point where the decision doesn't really meet the expectations of both parties, then we can back up and maybe get a different solution to the problem. But I don't, as a mediator, decide what it is that we talk about and who's right or wrong. So I don't force you into doing anything. All that I do as a mediator is control the room. And you, as participants in mediation, control the outcome of the conflict that you're involved with. So I listen, I explain their concerns to the other. Sometimes when people are in conflict, I know like in husbands and wives in a divorce, and maybe you can relate to this, that sometimes your spouse can say things to you that just gets you upset, that sometimes other people who say the same thing, it doesn't affect you because you have a history with that person. All right? Okay. So what I do as a mediator, knowing and being able to read body language, when somebody says something that I see might inflame the other person's sensibilities, I'll take that statement and I'll reframe it. So what I hear you saying is this. Or if somebody says, I think you're a stupid jerk. Oh, what I hear you saying is you disagree with this person's point of view. And trying to soften the statement and keep the dialogue going and the conversation talking. And so I try to help them develop and agree upon some kind of solution that everybody in the room, now just because one person thinks the idea is good and the other person doesn't, we don't have an agreement. And when it comes to elder care mediation, everybody who's participating has to agree to the solution or we don't have an agreement. So it's not muscling or pushing or manipulating the process in order to get your way to do something, everybody has to agree. That's why mediation is safe. It's non-adversarial. Well, mostly, but when people do come into the room, they have strong points of views and positions, and they're trying to exert their point of view and trying to convince other people why they're right and why the other people are wrong. But ideally, it's non-adversarial. And mediators stress collaboration, working together to solve the problem, as opposed to trying to muscle one point of view onto the other parties there. It's not a win-lose approach, it's called a win-win approach. And it's flexible. So, what the court might understand to be the perfect solution, you know, the court sometimes has a cookie-cutter approach that we just do it this way, and the court imposes their decision upon both parties, and the imposition of that decision might not work for everybody involved, and so everybody involved loses. Or maybe one person wins, but one person loses. And if one person loses, there's a high probability that we're going to end up back in court because that loser in the situation wants to win. So mediation strives for a win-win approach. And it really stresses self-determination, that you get to make the decisions, you get to determine the outcome, you solve the problem, the mediator does not. It's efficient in the sense that it takes less time. It's efficient in the sense that it costs less money. Mediators cost typically much less than what maybe an attorney or two attorneys would cost. Now imagine in a situation where maybe in eldercare mediation that you would have two people fighting over who should be the ward of the person that they're probating. Do you understand? And so if there are two people fighting and they have two different points of view and they're going to court, that's two attorneys. And that's a lot of time, and there's lots of paperwork to file. And lawyers are great people, but sometimes it just costs a lot of money. Mediators try to get everybody in a room so that they can talk to themselves. So instead of paying multiple fees, mediators are just one fee, and that fee is spread typically or divided up amongst all the participants who are in the room. So therefore, mediation is much more cost-effective.